faced with a difficult decision. This law has been stated. It has not been. This is a case of first impression, as far as this court can tell, with respect to how these laws were applied in this manner. And I made my rulings with respect to the law. And really, the court boils it down to a couple of things. And I believe the jury did the correct thing. They boiled it down to the switching out of precincts. Pre-counting, comparing to the unofficial count, discarding precincts that didn't match, and replacing them with precincts that did. So when the official recount in front of witnesses was held, that everything would add up. And that's what the jury found, and I believe they did a good job. They boiled it down to that. And all the letters I got with respect to this maiden, this dreamer, that they're dedicated, good employees, that this dreamer has binders full of all the Secretary of State opinions and directives, and all the information handy, that she was extremely knowledgeable, extremely vigilant, detail-oriented. These are the people who wrote letters on your behalf, indicated that's the type of person you are. That I can't fathom how you couldn't understand that the process that you did was wrong. It was a charade when you did the official recount in front of witnesses. It was predetermined. It wasn't random. And it's a simple matter of right and wrong, not technical legalities of what their duties were. Your duty was to make the process transparent, to make the process open to everybody, to ensure people, to reassure people, because you were under so much scrutiny that year, that, look, folks, here's how we do it. We got nothing to hide. And if we have some blemishes, if there's some minor mistakes with respect to how the ballots are counted, this is what the recount procedure is all about. We'll figure that out and we'll address it. And it'll be open to everybody. And that's the only way that our democracy can function. I mean, the right to vote, that civic responsibility, that civic right that you even alluded to, Ms. Maiden, people didn't have all the time in this country, that people fought for, protested for, died for, the right for everyone to be able to vote. That it's an important process, that it be an open, transparent process. And I can't escape that you had to know that it was just wrong. It was a fraud on those witnesses. It was a fraud on the public. It was not making the process transparent. It wasn't reassuring people that all the votes will be counted. A right that everyone holds dear, that if people have no confidence in the system, then what good is a democracy? That there's been indications that somehow you two are scapegoats, some kind of political pawns, that you're protecting other people. I don't know. It seems unlikely that your superiors wouldn't know exactly what you're doing, and that you wouldn't have conversations with them about this process. You've admitted today that there were conversations that you can't quite remember exactly now, and that if that's true, you put yourself in that position. And telling the whole truth is what's important. Giving all the information you have to get to the bottom, which, if it made some mistakes. We're not going to do that again. We were following directions. That's all we were doing. And you can't even say that. You can't even tell this court, state of Ohio, that. And so you put yourself in this position that it's such an important public trust. It's such an important part of our democracy. The court has to apply the law with that seriousness factor in mind. And what's to deter other people from saying, well, I didn't know it was illegal, technically, something we always did, and there was no testimony that was the way it was always done. None at all. And no testimony that people consulted the county prosecutor's office approved of pre-counting, excluding precincts, so that the final recount was really just a show. And if I misinterpreted this evidence, if I misinterpreted the law, I'm sure I'll be told, and I'll welcome the guidance from the Court of Appeals. But I don't know how else to deter people from taking this seriously. I don't know how else to impress upon people that it's such an important right that it can't be tampered with in any way. And I just can't accept that you didn't think that what you were doing was wrong. And I appreciate your whatever candor you're able to give today from a bunch of people. I hope that you consider further going back in your memories, deciding what other information might be helpful to get to the bottom of this. And that you don't decide to not give any other information that you might have. And that you work to keep the process open and transparent. And I'm not convinced you've done that. And all the arguments of counsel with respect to the factors, the seriousness factors, the citizen factors, it's all true, and I agree. And this is not normally law-abiding citizens that I want to punish with prison. But I can't help but feel that there's more to the story that hasn't been told. And that disappoints me. And that indicates a lack of remorse and a further corruption of the public trust. And I suppose that you'll have to search your soul. No one knows what happened more than you and God. And that's, political considerations. If this decision, has feelings of vengeance that needs to happen politically, ironically, you could do that with the vote, with the right to vote. The very thing that you devalue by your conduct. That's the irony that the court recognizes and that the court is working to preserve. So I'm going to pose the following sentence. With respect to the felony of the 4th degree, the court's going to impose a sentence of 18 months in higher reformatory for women. For both of these defendants, the court will impose a 6-month sentence on the misdemeanor. Out of order. Out of the courtroom. Out of the courtroom. Out of the courtroom. 6-month sentence will run by law concurrent with the 18 months. Post-release control is part of this sentence by law. Time your release will be supervised by the Ohio Adult Parole Authority for up to 3 years. You have to follow the rules of the Parole Authority. If you fail to do so, the Parole Authority will have the authority to send you back to prison for up to 50% for this 18-month sentence. Also, if you fail to report your parole officer, you're subject to being sent to prison and also being subject to a separate indictment called escape. And the court who gets that new indictment can also punish you by sending you to prison. The court understands that you also, and I'm going to express this, that you have a right to appeal the conviction, the sentence. That I understand that there's legal issues with respect to this trial, unique legal issues, and so the court is willing to consider an appellate bond with respect to the sentence, and also hope that you consider your position in this matter, and that if there's more information forthcoming, that the state of Ohio may come to an agreement with your attorneys with respect to a sentence. Also, you have a right to appeal the conviction. And I feel compelled to say this to both of you, and especially Ms. Dreamer, because as you recall, when we started this trial, there was issues with respect to potential conflict of interest with your attorney. And we discussed that on the record, and you indicated that you were comfortable with those conflicts. And I'm not privy to any of the advice that you were given. And so, therefore, I want to tell you that one potential issue for appeal would be that conflict. Also, argument for ineffective assistance of counsel. I'm not saying that that's present in this case, but I feel compelled to let you know that you may want to have a different attorney as far as the appeal goes. It's difficult for an attorney to allege in his own pleadings that he was ineffective. And most trial attorneys do have a different attorney handle the appeal. And I would ask or encourage both of you to consider that. If you can't afford an attorney, the court is available to appoint an attorney for you for the appellate reasons. And I think you should seriously consider that.
Would the court consider naming an appellate bond at this time?
And would you also consider, Judge, a motion to stay execution of the sentence at this time, Judge? So that we will post an appellate bond, Judge. In light of that, we would ask that Mrs. Dreamer and Mrs. Maiden not be required to be incarcerated at this time. We would ask that the execution of the sentence be immediately stayed.
All right, the court will grant that motion. I'll stay the execution, I'll grant appellate bond. The state of Ohio have requests with respect to an appellate bond?
Not particularly.
The court will set a $2,500 cash or surety appellate bond in this matter and allow the defendants to remain free pending posting that bond.
Thank you.
Anything further? No.
Thank you.
All right.
All rise.
Cases.
Yeah, 18.
Okay, now I may not be able to get back.
Sure.